The courtroom had gone completely still. Judge Patricia Wren, a woman who had presided over federal civil court for 19 years and had seen nearly everything, looked down from the bench with an expression that hovered somewhere between confusion and controlled fury. She had just been told 3 days before trial that the lead counsel for the defense had withdrawn. Not stepped aside gracefully, withdrawn. Filed the paperwork on a Friday afternoon when the clerks were already thinking about their weekends. The defendant sat alone at the defense table. Her name was Serena Caldwell, and 4 months ago she had been the founder and CEO of Caldwell Bioseed, a company that had spent 11 years developing a drought-resistant grain variety that could grow in depleted soil with 60% less water. Agricultural scientists called it a quiet revolution. The Department of Agriculture had quietly called it something more. A threat to the commodity pricing structure that kept certain very powerful people very comfortable. Now Serena sat with her hands folded in front of her, her posture composed in the way that people learn to sit when they are exhausted and terrified and have run out of moves. She was 44 years old. She had mortgaged her house twice for this company. Her daughter was 14 and had not slept well in 3 months. The charges against her were securities fraud and misrepresentation to investors. The government's case, or rather, the case being driven by a private civil complaint from Vantage Agricultural Holdings, the largest industrial farming conglomerate in the Midwest, alleged that Serena had deliberately overstated her seed yield data to attract Series B funding. It was the kind of charge that, if it stuck, would not only end her company but follow her name for the rest of her professional life. What nobody in that courtroom knew, except the people who had arranged it, was that the yield data had been accurate. Every number, every field test, the falsified version, the one now entered into evidence, had been substituted 14 weeks earlier by someone with access to her company's document server, someone who had been paid to do it. And the law firm that had just withdrawn, Kessler & Farrow, with its mahogany lobby and its $9,000 hourly rates, had known, or at least 2 of its partners had known. They had filed a motion to withdraw citing an unresolvable conflict of interest, collected their retainer, and left Serena Caldwell 3 days before trial with nothing. Judge Wren set down her reading glasses. "Mrs. Caldwell," she said, "I need to understand your situation before we proceed." Serena looked up. "I understand, Your Honor. You are currently unrepresented. Yes, do you intend to seek new counsel?" There was a pause that lasted only a second but felt much longer. Serena opened her mouth, and then something happened at the back of the courtroom. The doors, heavy oak with brass handles, opened quietly. The bailiff turned. A few of the spectators turned. The man who walked in wore dark gray work pants and a collared shirt that had been ironed but was beginning to show its age at the cuffs. He was somewhere in his early 60s, with the kind of face that had been weathered by something other than sun. The particular weathering of someone who had made a decision once, a long time ago, that cost him everything he thought he was. He carried a worn leather briefcase that looked like it had been in storage. He walked straight to the defense table, set the briefcase down, and spoke in a low, even voice. "Your Honor, my name is Owen Ferris. I am a member of the bar in good standing in this state. I am here to represent Miss Caldwell with her consent." Judge Wren stared at him. "Mr. Ferris." She looked at her clerk. The clerk was already pulling up the bar registry on her screen. She nodded once. "Your license is current. It is, and your client consents?" Serena looked at the man beside her. She had met him 11 hours ago. Under circumstances she was still trying to process. "Yes," she said. "She does." The judge studied Owen Ferris for a long moment. "I'm going to need more than 2 minutes to feel comfortable proceeding, Mr. Ferris. We'll take a 15-minute recess. I expect a full proffer of your qualifications and your readiness to proceed." "Of course, Your Honor." The gavel came down, and the courtroom, which had been still before, now erupted in the kind of low murmur that travels through a room when nobody can quite explain what they just saw. Owen Ferris had been the custodial supervisor at the Harwick County Courthouse for 6 years. He pushed a cart with a squeaking left wheel through the marble corridors at 4:30 every morning, before the judges arrived, before the attorneys arrived, before anyone arrived who might have recognized him or might have needed to be reminded not to recognize him. He liked those hours. The building was different at 4:30. Quieter than it had any right to be, given everything that happened inside it between 9 and 5. He lived alone in a 2-bedroom house about 4 miles from the courthouse. His daughter, Nora, was 26 and lived in Portland now, teaching middle school science and calling him every Sunday at 7. He had a cat named Bogart who ignored him with great dedication. His truck was a 2009 Ford F-150 with a cracked passenger mirror he kept meaning to replace. To anyone who saw him in the hallways, mopping, resetting the chairs in courtroom B, hauling recycling bags out through the service entrance, he was simply the quiet older man who did the work without complaint and went home without making a fuss. What they did not know, because Owen Ferris had made a careful and deliberate effort to ensure they did not know, was that he had spent 22 years before this as one of the most effective civil litigators in the state. He had argued before the state Supreme Court 7 times, won 5. He had tried cases that reshaped agricultural land use policy across 3 counties. He had been, at 38, the kind of lawyer that other lawyers called when they were in trouble. And then his wife had gotten sick, and the cases had kept coming. And he had kept saying yes, because the cases needed him, and because work was the thing that felt solid when everything else was dissolving. And by the time Ellen died, on a Tuesday in November, with the leaves half-gone from the oak outside their bedroom window, he had missed so much of the last year of her life that he could not remember the last conversation they'd had that wasn't interrupted by his phone. He had walked out of his office 2 weeks later, not resigned formally, not negotiated an exit, walked out, left his files with his paralegal, called the bar to confirm his license would remain current if he paid his dues and completed his continuing education, and taken a job pushing a cart through marble hallways at 4:30 in the morning. He told himself it was temporary. He told himself that for 6 years. He had seen Serena Caldwell for the first time 8 days earlier. He had been in the hallway outside courtroom A, replacing the burned-out fluorescent fixture in the overhead panel, when she had come out of a pre-trial conference with her then-attorney, a Kessler and Farrow partner named Graham Tillis, whom Owen had seen in these hallways many times. Graham was the kind of lawyer who wore his confidence like a piece of tailoring. Everything fitted, everything deliberate. Owen had noticed, without particularly meaning to, that Serena was walking a half-step behind Graham, and that Graham was not slowing down to match her. He had noticed the way she was holding her folder, too tight, the papers slightly bent where her fingers pressed. He had noticed the look on her face when Graham turned away to take a phone call and she thought no one was watching her. He had looked away and gone back to the fluorescent panel, but that night, at home, he had found himself thinking about the case. He had been aware of it in the background. It was hard not to be, working in the courthouse, and the name Caldwell Bioseed had meant something to him. He had a nephew who farmed soybeans in central Illinois. He had read, in an agricultural journal he subscribed to out of habit, about what Serena's seed technology could theoretically do for small-scale growers working marginal land. He told himself he was just curious. He told himself that when he opened his laptop and pulled up the public court filings at 10 o'clock at night. He told himself that when he was still reading at 1 in the morning, because something in the documents wasn't adding up. The yield reports that formed the basis of the fraud allegations had been filed as Exhibit 14. Owen read them 3 times. Then he went and found the original SEC filing from Caldwell Bioseed's Series B round, which was publicly available. He put the 2 documents side by side on his screen. The numbers were not just different, they were different in a specific way. Not errors, not rounding, but a systematic reduction of exactly 18% across every yield metric, applied with a consistency that no honest mistake could produce. Someone had adjusted every single figure by the same margin, someone who was not Serena Caldwell, because the adjustment had been made after the Series B filing and before the complaint was filed, and the metadata on the altered document, buried in the file properties, not something anyone would look for unless they were looking, showed a modification date that didn't match the document's claimed creation date. Owen sat very still for a while after that. He made himself a cup of coffee, which he didn't drink. He stood at his kitchen window for a few minutes, looking at the dark backyard. Bogart jumped up onto the counter and sat next to the coffee maker with professional indifference. Owen went back to the laptop and kept reading. By 3 in the morning, he had found 2 more things. First, an email chain that had been included in the discovery documents. Kessler and Farrow had apparently moved to include it. then quietly failed to highlight it in their pre-trial brief, in which a mid-level employee at Vantage Agricultural Holdings discussed the Caldwell situation with someone whose email address was redacted. The language was careful, but not careful enough. The repositioning of the data needs to be complete before the filing date, one email read. Once it's in the record, it stays in the record. Second. The motion to withdraw filed by Kessler and Farrow cited a conflict of interest. Owen pulled the firm's client list from their public disclosures. Vantage Agricultural Holdings had retained Kessler and Farrow for unrelated corporate work 2 years earlier. The conflict was real. It was also the kind of conflict that ethical attorneys were supposed to identify before taking on a conflicting client, not 3 days before trial. Owen closed the laptop. He sat in his kitchen for a while longer. The refrigerator made a sound. Bogart fell asleep. He thought about the look on Serena Caldwell's face in the hallway outside courtroom A. The folder held too tight. The half step behind, he thought about Ellen. Not about her death, not about what he had missed. He had thought about those things enough that they had worn smooth, like stones in a riverbed. He thought about something she had said to him once early in their marriage, when he had been agonizing over whether to take a case that was winnable, but would take 2 years of his life. She had looked at him across the dinner table and said, simply, "Owen, you know what you're for. Stop pretending you don't." He opened the laptop again. He had gone to the courthouse the next morning at his usual time. He had pushed his cart. He had replaced a soap dispenser in the third-floor men's room and unclogged a drain in the jury assembly area. And at 10:15, when he knew Serena Caldwell had a scheduled meeting with the victim's advocate on the second floor, he had positioned his cart near the elevator and waited. She had come out of the meeting room alone. He had stepped forward, not in her path, just near enough to speak quietly. "Messieurs, Caldwell." He kept his voice low and even. "My name is Owen Ferris. I work here. I've been following your case through the public filings, and I found something in the documents that I think you need to see." She had stopped walking. She had looked at him with the particular wariness of someone who had been approached by too many people with too many things they wanted her to see. "Are you a journalist?" "No." "A consultant?" "No. I'm the custodial supervisor." He paused. "I'm also a licensed attorney. I've been inactive for 6 years, but my license is current. I want to show you something I found in your discovery documents." She had studied him for what felt like a long time. She was not naive. She had built a company from nothing, which meant she had learned to read people accurately and quickly. She looked at the worn briefcase. She looked at the work pants. She looked at his face, the weathered, patient face of a man who had no angle visible anywhere in it. "All right," she said. "Show me." They had sat in the third-floor conference room for 2 hours. Owen had brought printed copies, tabbed and annotated in the precise margin-filling way that was the artifact of 2 decades of case preparation. He walked her through the metadata discrepancy. He walked her through the email chain. He walked her through the timeline of Kessler and Farrow's conflict of interest and what it meant in terms of their ethical obligations. Serena had said very little during this. She asked 2 questions, both precise, both getting at exactly the weakness Owen expected her to get at, and then she was quiet for a while. "Why are you doing this?" she said finally. Owen had thought about how to answer that, and decided that the honest answer was also the best answer. "Because someone altered your documents and built a federal case on the alteration," he said, "and the attorneys who were supposed to notice that either didn't or didn't want to. And if nobody says anything, you go to trial in 3 days with nothing and you lose. And the people who did this continue doing whatever they want. And you can actually try this case. I haven't tried a case in 6 years. I've kept my education current and my license current, and everything I've told you tonight is accurate. Whether I can try it well enough is a different question. But I think the materials speak for themselves if they're presented correctly." He paused. "I think we should file a motion with the court tonight to formally enter my appearance and request a brief continuance for additional preparation. Judge Wren will likely grant it." Serena looked at the printed emails on the table between them. She had spent 11 years on this company, the grain that grew in depleted soil, the small farmers who needed it, her 14-year-old daughter who had stopped sleeping. "If I lose anyway," she said. "Then you lose with the right evidence on the table," Owen said, "which is different from losing without it." She had nodded, slowly. Judge Wren granted a 4-day continuance. She also noted for the record that the motion to withdraw filed by Kessler and Farrow had raised concerns she intended to refer to the State Bar's Ethics Committee. She used the phrase, apparent conflict of interest, with the carefully neutral intonation of a judge who has already formed an opinion and is choosing her words for the transcript. Owen Ferris spent those 4 days the way he had spent the 4 days before every major trial of his career. Sleeping less than he should have, eating whatever was convenient, reading until his eyes hurt, and working backward from the weakest point in his own case to find everything that could be attacked. The weakest point was the metadata evidence. It was technically sound. He had a digital forensics consultant he had contacted through a law school friend who confirmed the analysis and agreed to testify as an expert witness. But juries sometimes glazed over when digital forensics got complicated, and he needed to make sure the core point was clear enough that it didn't require technical fluency to understand. He built the presentation around a single, simple frame. The document in evidence said it was created on one date. The file itself said it was modified on a different date. Not a small difference. A difference of 4 months. 4 months after the original report had been submitted to investors. 4 months during which the company had changed hands, during which Vantage Agricultural Holdings had acquired a minority stake in Caldwell Bioseed's primary licensing partner, during which 2 partners at Kessler and Farrow had accepted work from Vantage. He also subpoenaed phone records. This was the part Owen had thought longest about. Subpoenaing phone records in a civil case required a showing of relevance, and the relevance here was specific and narrow. He wanted records from a particular 3-week period for a particular Kessler and Farrow partner and a particular executive at Vantage. Judge Wren, after reviewing his brief in chambers, allowed it. The records came back within 48 hours. They contained 6 calls between Graham Tillis and a Vantage executive named Philip Morse. The first call was 2 days before Kessler and Farrow's engagement by Vantage on unrelated corporate work. The last call was the day before Kessler and Farrow filed their motion to withdraw. Owen read those records on his kitchen table at 2 in the morning and sat very still for a while. Then he called Nora. It was 11 o'clock in Portland. She picked up on the second ring because she always picked up when it was her father. "Dad, everything okay?" "Yes," he said. "I just wanted to hear your voice for a minute." She paused. She knew her father. "Are you in the middle of something? I might be." Another pause. "Is it a case?" He had told Nora the previous summer that he had kept his license current. He had not told her why. She had not pushed because she was his daughter and she understood the particular silence he kept around certain things. "Yes," he said. He heard her exhale slowly. "Good," she said. "I've been waiting for this phone call for 6 years. The trial lasted 4 days. On the first day, Owen Ferris entered the courtroom in the same gray work pants and the same slightly worn collared shirt, carrying the same aged briefcase. The opposing counsel, a team of 3 from a Chicago firm retained by Vantage, in suits that had been pressed that morning, looked at him with the carefully managed absence of expression that experienced litigators use when they are not sure what they are looking at. His opening statement was 11 minutes long. He did not use a single rhetorical flourish. He explained in plain language what the defense would show, that the yield data underlying the fraud allegation was accurate, that the document entered as evidence had been altered after the fact by parties with financial interest in discrediting Caldwell Bioseed, and that the law firm retained to protect Serena Caldwell had known, or should have known, that it was working against her interests. Serena sat beside him and watched the jury. She had learned, over the course of those 4 preparation days, to read Owen Ferris's pacing. When he was moving fast because the point was simple, when he was moving slow because the point needed to land. She watched the jury, and she watched them watching him, and she noticed something she had not expected. They trusted him, not because of his clothes or his credentials or his performance. Because he talked to them like they were intelligent, and he didn't seem to need anything from them except their attention. The expert witness on digital forensics, a retired cybersecurity consultant from the University of Michigan named Dr. Elena Pratt, took the stand on the second day. Owen had spent an evening coaching her on how to explain the metadata issue without losing a jury, and Dr. Pratt, who had done this before, had listened carefully and refined her explanation until it was clean and irrefutable. She put 2 images on the screen, the document as entered into evidence, and the document's file properties, which showed a modification timestamp of June 14th, 4 months after the alleged creation date, and 3 days after Vantage Agricultural Holdings had acquired its stake in Caldwell Bioseed's licensing partner. Is it possible, Owen asked, for this modification timestamp to be the result of a routine system update or automatic formatting change? No, Dr. Pratt said. The changes logged in the modification history are content changes. Specific numerical values were altered. That kind of alteration is not generated automatically by any software system I'm aware of. Someone typed new numbers into this document. The opposing counsel's cross-examination of Dr. Pratt lasted an hour and 15 minutes. It produced nothing useful for their case and left the jury with a clearer picture of the forgery than Owen's direct examination had established. On the third day, Owen called Philip Morse. Vantage's attorneys had fought this. They had filed 2 motions to quash the subpoena for Morse's testimony, and lost both. Morse came to the stand in a suit that was too heavy for the room's temperature, and he answered Owen's questions with the measured caution of a man who has been extensively prepared by counsel. He denied knowing anything about the document alteration. He denied discussing the Caldwell case with Graham Tillis. He denied any coordination between Vantage and Kessler and Farrow. Owen let him deny everything. He asked each question once, calmly, and wrote down the answer. Then he introduced the phone records. The moment was not dramatic in the way courtroom moments are sometimes dramatic in films. No gasp from the gallery, no Perry Mason collapse. Morse looked at the records and maintained his composed expression. But his attorney, watching from the gallery, went very still, and 2 of the jurors leaned forward. Owen walked Morse through each of the 6 calls, the dates, the durations, the sequence. He asked simply what had been discussed in a 47-minute phone call between Morse and Graham Tillis on a Tuesday in May. I don't recall the specifics, Morse said. A 47-minute call, and you don't recall the subject. We discussed several matters. I don't recall the specifics. Owen nodded, wrote something down, and moved on. He did not need Morse to confess. The records told the story, and the jury had seen the document alteration, and the only question was whether the sequence of events could be explained by coincidence. Owen's closing argument spent 20 minutes explaining, calmly and precisely, why it could not be. The jury deliberated for 6 hours. They came back on a Thursday afternoon with a verdict for the defense on all counts. Judge Wren accepted the verdict, and then, before dismissing the jury, made a brief statement. She noted that the court would be forwarding materials to the United States Attorney's Office regarding potential criminal conduct related to the alteration of documents entered into evidence. She also noted that the matter of Kessler and Farrow's conduct had been formally referred to the State Bar. She did not say anything further. She didn't need to. Serena Caldwell sat at the defense table for a moment after the jury filed out. She did not move or say anything. Owen watched her, and he understood. 6 hours of deliberation, after 11 years of building something and 4 months of watching it be dismantled piece by piece. There was no version of this that was simply relief. Relief was in there, but it was mixed with too many other things to be clean. He waited. After a moment, she turned to him. "Thank you," she said. And then, because she was the kind of person who needed to say the complicated thing rather than leave it implied, "I don't know what would have happened if you hadn't been standing by that elevator." Owen thought about that. "Something else would have happened," he said. "You would have found something. You're that kind of person. You don't know that." "No," he admitted, but it seemed like the right thing to say. She laughed. It was the first time he had heard her laugh, and it was good. It changed her face in a way that reminded him she was only 44, which was young, and that the last 4 months had made her look older than she was. There was, in the weeks that followed, a conversation that Owen had been avoiding. Serena called him the Monday after the verdict. Not about the case. The case was over. The appeal clock was running. Philip Morse's attorney had already begun making noises about cooperation in exchange for consideration, and the wheels of consequence were grinding toward the people who had set this in motion. She called him about something else. "I want to talk to you about what happens next," she said. "For you." "I'm fine," Owen said. He was standing at his kitchen window again. It seemed to be where he stood when important phone calls happened. "I know you're fine. That's not what I mean." A pause. "Caldwell Bioseed is still standing." I have work to do, which means I have attorneys to hire. Real ones, now that I know what that looks like. Another pause briefer. But also, I've been thinking about what you said. In the conference room, the first night, about losing with the right evidence on the table. What about it? There are a lot of people who can't get to the right evidence, because they can't afford the legal work it takes to find it. She stopped. I'm not proposing anything romantic or dramatic. I want to fund a legal resource clinic. Real attorneys, handling civil cases for people who can't access adequate representation. And I want to know if you'd be interested in running it. Owen was quiet for a while. Outside, a neighbor's dog was barking at something. He thought about the fourth-floor hallway at 4:30 in the morning. The squeaking wheel on the cart, the marble floors, quiet and cold, before anyone arrived. He had told himself it was temporary for 6 years, and there was something he had never quite admitted to himself, which was that temporary had never actually been the point. The point had been to stay close enough to the work, close enough to the buildings where it happened, close enough to the documents and the arguments and the quiet machinery of justice grinding, without having to be accountable to it, without having to answer for what he could do, without having to be again the person Ellen had told him he was. I would need a full staff, he said, not just attorneys. Paralegals, investigators, administrative support. The cases that need this kind of clinic are not simple cases, I know, and it has to be genuinely independent, not a PR arm of Caldwell Bioseed. Real independence. That was always the intention. He looked at the window. The dog had stopped barking. The yard was very quiet. All right, he said. 6 months later, the clinic, which Serena had insisted on naming Ferris Legal Aid, over Owen's extended objection, occupied a suite of offices in a converted building 3 blocks from the courthouse, where Owen had pushed a cart for 6 years. The sign on the door was modest. The staff was 7 people, 2 attorneys, a paralegal, an investigator, and administrative support. They had taken on 11 cases in their first month. 3 of them involved agricultural land disputes. 2 involved wrongful denial of disability benefits. 1 involved a small restaurant owner who had been defrauded by a contractor and had no idea she had standing to sue. Owen Ferris drove to work in the 2009 F-150 with the cracked passenger mirror that he had finally gotten around to replacing. He arrived early, as he always had, because early mornings were when he thought most clearly. He made coffee in the small break room and stood by the window that overlooked the parking lot and organized what needed to happen that day. He was wearing a different shirt now, still collared, still plain, but newer. He had called Nora the previous Sunday at 7, as always. She had asked how the clinic was going. He had said it was a lot of work. She had said she knew. He had said he slept better than he had in 6 years. There was a pause on the line. Then she said, "Mom would have had thoughts about that." "Yes," Owen said. She would have said, "I finally remembered what I was for." He could hear Nora smiling through the phone. "Yeah," she said. That's exactly what she would have said.